Hello again, everyone. This is Rob Ryder, and it's January 13th, 2016. That would be a Wednesday. And we're going to talk about the assessor role, different forms involved with the assessor. This is a lot of background information for me, for sure, and probably for you. And so I don't know that we're trying to do anything with it exactly yet, but you need to be aware of this and then start to go to look maybe for certain pieces of paper. Because as this oath of a town assessor says, that to the best of my ability, that I will without fear or favor appraise all property in said town at its fair cash value, said value to be ascertained at what the property would bring at a voluntary sale in due course of business and trade, and that I will assess said property when so appraised at full cash value. That I will cause every person, company, or corporation assessed to sign his, her, or its assessment schedule, and will administer to each and every person so signing said assessment schedule the oath thereon, and return said schedule to so signed and file the same as required by law. The problem, that is, nobody's doing this. This says that this gentleman, the town assessor, the town of St. Charles, County of Kane, State of Illinois, he will cause every person, company, or corporation assessed to sign his, her, or its assessment schedule. Well, so they haven't done that, and so why is that? Is it because you haven't told them that you're there? Right? You haven't appeared in the town yet, and that's what it appears to be, something like that. And so the town assessor, he puts the value on property and he collects the taxes, but he doesn't determine what the tax is. That happens in between his two other hats by somebody else. That's not, this is not letting the left hand know what the right hand is doing. So he's going to make this assessment roll and give it to these people called the Board of Review, and they're going to do their thing, and then it's going to go to these people called the Equalization Department. And they're between the Board of Review and the Equalization Department, they're going to determine the tax, give it back to the assessor, and he's going to go collect it. Right? So he doesn't really know what's happened in between times. He just knows he created a list, and now here's the tax for the people on the list, and he needs to go collect them. So what is that all about? Let's take a look at a few things. So, in Michigan, this is Michigan Compiled Law 211-19, which is in the Property Code section of the Michigan Compiled Laws. It says, a supervisor or other assessing officer, as soon as possible after entering upon the duties of his, her office as required under provisions of any charter that makes special provisions for assessment roll or assessment of property, shall ascertain the taxable property in his, her assessing district, the person to whom it should be assessed, and the person's residence. Except as already provided, the supervisor or other assessing officer shall require any person whom he believes to have personal property in a possession to make a statement of all personal property of the person, whether owned by that person or held for the use of another, to be completed and delivered to the supervisor or assessing officer on or before February 20th of each year. A notice the supervisor or other assessing officer provides regarding the statement shall do all the following. And the key word in that is the notice, right? So they need to notice people that they have to fill out this form. And really, I mean, it's the same form as the guy with the oath is talking about. And so in Michigan, they combined it all at one form. So this is the form that they're speaking of with that section of law, the personal property statement. And you can see that at the from, it's the name and the address of the assessor. So the assessor is supposed to be sending this to the name and address of the taxpayer. Well, I've never gotten one of these. I lived in this particular house for going on 12 years now. Never got one. It's a multi-page form that, blah, 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 you're supposed to fill out. So why hasn't the assessor given me one of these? Well, apparently he doesn't know I'm in his jurisdiction. And if I'm not in his jurisdiction, then I must be in a different jurisdiction. And I'm going to say that that's the jurisdiction where all the ad valorem taxes are. Then in this jurisdiction, right, this would just be the general taxes, the excise taxes, the taxes of the sovereign. Most of the taxes you pay have nothing to do with the state. They're special interest groups that got the right to charge a tax. Maybe it's more complicated than that, but at the end of the day, it ain't them. Right? It's not the state, or I don't believe it is. So I'm going to go and try to get on this assessment roll and see what happens. And the assessment roll in taxation is the list or roll of taxable persons and property completed, verified, and deposited by the assessor, not as it appears after review and equalization. Deposited by the assessor in the left hand and review and equalization is the right hand, and they don't know what the two are doing. And we can talk about a mill in just a second, and a mill has to do with basically 1/10 of a cent, or 0.001, right? Property tax in dollar terms and calculated by multiplying the assessed value by the property mill rate divided by 1,000. Okay. What's that all about? Well, we'll see in a second. That the personal property that we just spoke about, a certified personnel property examiner may examine only the property or the cost records relating to such property of any corporation, firm, or individual liable to assessment within their county, township, city for property taxes under this act. So I want this person to look at my property to determine what its value is. And because it went into Section 3 to say when any corporation, firm, or individual is subject to personal property assessment in more than 3 counties of the state, then the corporation, firm, or individual may request an examination be made at their expense by a representative of the state tax commission at a rate of 1/10 of 1 mil of the gross value of the personal property of said corporation, firm, or individual under examination. And I say my Social Security account that is my personal property. All caps is my personal property. So I want them to go and, see what the assessed value of it is. Charge me the 1/10 of 1 mil and, give me the rest. Take care of the debts, set things off, and give me the rest. Okay. Now, property tax assessment roll. Okay, a little bit on the roll. So the assessor is the one that does this. He's the one that makes the roll. What is the roll? On or before the first Monday of March, the assessor shall make and complete an assessment roll, upon which he shall set down all the following: the name and address of every person liable to be taxed in the local collecting unit, with full description of all real property liable to be taxed. If the name of the owner, occupant of any tract or parcel of real property is known, the assessor shall enter the name and address of the person or occupant opposite the description of the property. So there should be this roll, and it should have the property on, and it should say who the owner is. If you think you own your property today, I'm afraid I'm going to have to tell you that you're incorrect, because the deed's never been transferred. The bank never lent you any money. They didn't sign the contract. Lots of crazy things that happen. But at the end of the day, the reason the bank didn't lend you any money is because everything's already been bought and paid for by our Lord Jesus Christ, and you just need you want the beneficial use. You want the rights, title, and interest to certain properties for your they're called ownership rights: right to use, right to enjoy, right to dispose of. But if you leave, and they put this time of 6 months on it, and you don't come back, well, the property is considered vacant or abandoned, and they could give it to somebody else. So really what you want to do is, it looks like you just pay to have the title transferred. That's what the $10 is for. And more on that later maybe, but it's things we talked about before. I don't really need to go into it again. The important thing is that right now, if you went to your local assessor, so I live in a township, the township has an assessor, has a township assessor. I don't own property, so I really can't do this, but if you do own property, right, you want to go down and look at the assessment roll to see, find your property and see if it's got your name by it. And what's actually happening is you're being double taxed because they're using more than one descriptor for the property, and we're not pointing out their error to get it fixed. And if you did, then you wouldn't pay tax in the fictional jurisdiction. You would just pay it in the de jure jurisdiction. So if unknown, the real property described upon the roll shall be assessed as owner unknown. Well, if you can find any property that's owner unknown, you can put a claim on it. It's abandoned property, right? You're claiming the land. It just happens to have a house on it. That isn't what you're claiming. You're claiming the land. Something like that. This is, ideas in the head. I haven't tried it yet, but I think it could be done. Each description shall show as near as possible the number of acres contained in it as determined by the assessor. Well, this is how you can tell right away if they're using the proper descriptor on your taxes and so forth, because if I went to the assessment website, not the assessment website, the Department of Equalization for Kent County, and I looked up this piece of property where I live now, you could already see here, well, we got two different kinds of numbers going on, one with dashes and one without. Same digits, but they're different numbers. And whatever this one is, right, so the one with the dashes says its acreage and lot dimension is 0.00. Well, this just said that each description shall show as near as possible the number of acres contained in it as determined by the assessor. It is not necessary for the assessment roll to specify the quantity of land comprised in any town, city, or village lot. In other words, lots that are owned by the town, city, or village. Not individually owned lots. If it was an individual who owned it, they'd have to put the acres in there. So because this is 0, this is saying, well, the township owns this property. Well, how could that be? Well, it could be because they have the title, and the transfer's never been properly done, so it's been considered abandoned, and they took advantage of the abandoned property, and they claimed the title. So you need to go correct the record. True cash value, tentative taxable value, local school district, these are things that need to be on the paperwork. I'm not really going to get too deep into this now. I talked about it a little bit last time. But the assessment roll is different than a tax roll. Notwithstanding any other provisions of this act, a county by resolution of the Board of Supervisors may prepare tax rolls and extend the taxes thereon for cities and townships in the county at the expense of the county or local unit. So, tax roll is different than a assessment roll. Real estate index numbers, and this index number stuff, that's what these things must be, PPN and P number. An assessing offer with approval of the governing body of the city or township may establish a real estate index number. Who does it? The assessing officer. So you want to know what his indexing system is, not somebody else's. Right? There's two different numbers here, PPN and PNUM. Which one is his? The PNUM with the dashes was used here for this parcel number, PNUM parcel number. When it's used that way, their acreage is 0.00. What is it if you use this other number, and why aren't they using it? Well, we know why they're not, because they're stealing your property. Jeepers, go figure. Right? Don't make it any harder than it is. It's so they can steal your damn property. The assessing officer shall assign individual index numbers, and the assessment rolls, the tax rolls, and the tax statements shall carry the index numbers and not the legal descriptions, except that both the legal description and the index number shall be shown on the tax statement for the first year after this section is effective. Okay, we're going to give you one time to see what's going on, and then so we can say we've done it, show it to you, and we're taking it away. Index is established hereunder shall be open to public inspection. Well, ain't that sweet? So the assessment rolls, tax rolls, and tax statements shall carry the index numbers and not the legal description. Now it says numbers, not number. So there's something going on here. I don't know if these two numbers are valid or not. What I do know is when it's using the PNUM, it says there is no acreage, right? So this isn't for real estate. Real property, real estate, well, land, premise, however you want to define it. And then we have special assessment rolls. So those are the normal, but bridges, drains, curbing, culverts, additional rights-of-way deemed part of improvement. All bridges, road drains, drainage structures, curbing, culverts, and other additional right-of-way required, and any additional right-of-way required shall be deemed as necessary part of any proposed improvement, and the costs and expenses, therefore, shall be included on a special assessment roll for each or for such improvement. So not only do you have the yearly assessment roll, you have a special assessment rolls. And so this is where, for me, I'm going to take a little time and get the 5 or 6 things that I really want to know, study it in my head a bit, and then go down and talk to the assessing person to see what they can tell me. I've already sent a couple of pieces of paper, and we'll see if that does anything. But no judgment or decree or any act of the township board vacating a special assessment shall destroy or impair a lien of the township. And so, because there's no individuals, and I'll show you this on another piece of paper, there's no inhabitants of the township because we haven't done what we need to do to be on the assessment roll. The bills of the township aren't being paid, and there's liens against the township, which is everybody who lives in the township. And it put the local government into, in my opinion, into Chapter 11. But without getting too deep into this kind of stuff, because it just goes on and on. What I really wanted to do was spend a little time. So I went and found assessors manuals, right? Jeepers, you can find this stuff online. And this is State Tax Commission Assessors Manual, Volume 3. And the reason I'm in Volume 3 is I wanted to find something that had to do with assessment and tax roll preparation, real property descriptions, and they ended up being in Volume 3. Right? But what you want to know is how are they defining real property, or how are they describing it, and how are the rolls made? And if you can find something on personal property, that would be great too. But in this book, it says portions of this chapter are no longer applicable and are being revised at this date. There's no portion in there. But there is about assessment. And so I'm going to read for a bit, and you can find your version of this. This stuff isn't that hard to find, right? It's assessment and tax roll preparation. Right? So Michigan, assessment and tax roll preparation. Ohio, assessment and tax roll preparation. Indiana, assessment and tax roll preparation. Just put the name of your state in front of assessment and tax roll preparation and see what comes up. You're trying to find stuff that, from the state talking about assessments. Now, why this is important to me is all the forms that the assessment people use come from the Department of Treasury at the state level. They don't have a damn thing to do with any local paperwork coming out of the local township. They're all state tax forms. Well, that'd make it the Court of Exchequer if we were in England, because now we're talking about the King's Revenue. And the Court of Exchequer is a court of equity. And we're looking for equity. And an assessor is an ecclesiastic term, and it's an assistant to a judge. And so this isn't at the county. I have a township. If you have a city with a charter, well, it's going to be in there. Now, they may not call themselves an assessor, but they'll talk about assessments. And they may talk about the tax collector. But the idea is, well, who's doing the assessments? Every jurisdiction, every local jurisdiction has somebody responsible for doing the assessment. And then they send their information up to the county for it to go through the board of review and then into the equalization department. But we want to see it and make sure it's correct at the local level. So what's on the roll? So let's go. Let's see what these things say. I don't know how that shows up when I do that. I probably should make it quite that big. Shoot. Okay. The purpose of this chapter is set forth what an assessment roll and tax roll, two different things, assessment roll and tax roll, should contain, and what form they should be prepared. Sections from the Michigan compiled laws, state tax commission are often cited, blah, 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 blah. The assessment roll. There is only one annual assessment roll for each assessing unit. The assessment roll is the one roll which assessments determined by the assessing officer, reviewed by the Board of Review, equalized by the County Board of Commissioners, and containing the certificate of all three. To avoid confusion, it's strongly recommended that all copies, duplicates, and alterations of original roll either should not contain the word assessment in their labels or should be clearly labeled so they're not confused with the original assessment roll. What roll do you want? You want the original assessment roll. And as you can see, it goes through these three things, and they each have to put a certificate on it. Boom, 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 right? So everything's certified. The assessment roll will be completed in accordance with the general property tax law by the duly elected or appointed assessor, who is properly certified by a state assessing board. Well, there you go. Right? They got to be qualified. The roll shall be bound in volume or loose leaf pages bound into a permanent cover containing all real estate and personal property in the township, city, village for which the roll is prepared. That's the book you want to look at. And that's public record. They have to show it to you. Prior to presentation to the Board of Review, the assessment roll shall have a certificate attached, signed by the assessor, including his or her certification number. The roll shall be completed and prepared for presentation to the Board of Review no later than the first Monday of March for the township as provided by charters in cities. So a township is under the general law and a city is under its charter. Simple enough. All entities in an annual assessment roll shall be machine printed or hand printed in ink. In all cases, any erroneous entry should be lined out, initialed, and dated. There should not be any erasures in the assessment roll. There you go, man. Look for eraser marks. During legally prescribed meetings, each official action to change assessment by the Board of Review shall be entered by the board in a permanent ink in a column reserved for the Board of Review. If an assessment is upheld following a petition to the Board of Review filed by the property owner, the assessment should also be entered in ink in the Board of Review column. After an assessment roll has been reviewed by the Board of Review, a certificate signed by members of the Board Review is permanently attached to the roll. It contains the total valuation of each classification of real property and the personal property separately and finally determined by the Board of Review. So the Board of Review is going to determine what the total valuation is of each classification of property. Well, whatever that means. I haven't seen them yet, right? But when you get them, then you go back and you read this stuff again with the paperwork in your hand, and you say, oh, okay, well, this would go here, and this would go here, and this would go here. And that's, we're auditing their procedures. After attachment of the certificate, no assessing officer is permitted to make any entries in the roll except by written authority of the Michigan Tax Tribunal. There you go. Once it's in, it stays in. The assessor may not make any divisions of the assessment in the original roll or change any assessed valuations, even though errors have occurred. Mutual mistakes of fact or clerical errors can be corrected at special sessions of the Board of Review held only for this purpose at statutory dates in July and December. They got those 2 days to fix their errors. A correction may be made in the year the error was made and the following year only. Omitted or incorrect reported property liable for taxation can be added to or corrected on the current assessment roll by the State Tax Commission for the current assessment year and 2 years immediately preceding. It's getting kind of dry. If for purposes of convenience, the assessment roll must contain 2 or more volumes, there is still only one assessment roll for each township, city, or village. It is recommended that at the end of the last volume, 2 or 3 blank pages be left for attachment of the certificates of the assessing officer, the Board of Review, and the County Board of Commissioners. Well, there you go. If you want to know if you're looking at it, somewhere in the book has to be the certificates. Properties in an incorporated village are assessed by township assessor, by the township assessor, reviewed by the Township Board of Review. Okay, so villages are handled by the township. Cities have a charter. They take care of themselves. Completed assessment roll shall be delivered to the County Equalization Director no later than 10 days before adjournment of the Board of Review. Upon completion of county equalization, the assessment roll should be returned to the assessing unit with a permanently attached certificate from the County Board of Commissioners attesting to the county equalized value of each class of real property and of personal property in the unit. Okay, so each assessment roll must contain the following columns: name and address of owner or occupant, property description or permanent parcel number, including the school district code and property classification. The school district code is important. That goes back to Thomas Jefferson and the elemental republics and doing the congressional / survey townships, which section 16, basically lot 16, I should say, right? Because each of them mile squares was considered a lot. Lot 16 went to the school. So there's something about school districts. Just point that out. And again, these are things that have to be in this roll. The assessor's valuation, Board of Review valuation, Michigan Tax Tribunal or Tax Commission valuation. Well, that's interesting. They're going to have a valuation too. A brief description of each follows. Name and address of the owner-occupant. The name of the owner of record should be listed if known. A purchaser of land contract is considered the owner of record. If the owner is not known, the person occupying or in possession should be listed. That would be me. If no owner, occupant, or possessor is known, then unknown should be listed. The last known address of the person listed should be used. So it very well could be that they have your name with a shitty address, right? And you're not getting the mail. That's a possibility. Name and address of owner or occupant. Because your mailing address has nothing to do with the physical address of your property. Again, mine says Rockford, Michigan, which is 10 miles away from where I live. Property description or permanent parcel number. All descriptions of real estate must include in the assessment roll both taxable property and exempt property. Each parcel of real property should have a parcel code number assigned. The legal description for the real property should be listed in an orderly manner by section and plat. Go look at them laws to figure it out. Each description, except town, village, or city lot, should show the number of acres as near as can be determined. So 0.00 is not correct. Right? If you have a fraction of acre, well, it's still a fraction of an acre, but it's more than 0. But they don't have to if it's a city, town, or village lot. And again, that's what I'm saying. They're the ones who are claiming to be the owner of the property. Or at least it's abandoned property, and so it's, it reverts back to all the property reverts back to the sovereign. And so it goes back to the state through them agencies, because they're there to make sure that all the property is assessed, and if it's not being used, that it goes back to the state. If a township or city has received written state tax approval for use of permanent parcel numbering, so that would be good to know. Do you have the approval to use the numbers you are? The number of the parcel may be substituted for a geographical description in the column provided for descriptions. So, if you got anything besides a written out description, and they got a number in there, what do you have authorization to use that number? Description column should be included for identification of any school district in which the property is located and a classification of the property. Assess valuation. Taxable status of a person and real and personal property shall be determined as of each December 31st, which shall be deemed tax day. The assessing officer may survey, examine, or review properties at any time prior to or after tax day in preparation for the assessment roll. Any time prior to or after, well, that's pretty much any time he wants to do that. Use the assessor's manual or a manual approved by the State Tax Commission is required in arriving at the assessments. And so that, this book has got all these things about how you assess all sorts of property in there. And for now, I'm not interested in that. I just want to know what a roll is, and really how do they do the numbering system so you can tell if they're using a correct number. For personal property, for real estate, real property. All assessing officials shall maintain records relevant to the assessment, including appraisal record cards, historical assessment data, tax maps, land value maps, consistent with standards set forth in the Assessor's Manual published by the State Tax Commission. Wow, that boy's got lots of information. Right? Because a good real property legal description is one that you can give to a surveyor, and he can go close the box by surveying it. Find the four corners. Mutual stake of fact, okay. Essential law description of exempt real property is included. An assessment roll listed as exempt, okay, but it has to be there even if it's exempt. Other rolls, roll preparation also includes an assessment of property taxable under the following acts. These special tax rolls are subject to an addition, revision, repeal, or legislation may change subsequent to printing of the chapter. So they have all these so these would be special assessment rolls. Taxation of lessees and users of tax-exempt property. Commercial Forest Act, Commercial Facilities Tax Assessment Roll. Technology Park Facilities Assessment Roll. Industrial Facilities Tax Assessment Roll. Tax roll is a separate and distinct from assessment roll. Let me say again, a tax roll is separate and distinct from an assessment roll. The assessment roll contains the assets, the assessed valuation, and the valuations are revised by the Board of Review, the Michigan Tax Tribunal on appeal, the Tax Commission on omitted or incorrectly reported property, and Tax Commission, so forth. The tax roll shall contain a column for, so now they're saying the tax roll shall contain a column for property owner and agent and address. Well, we just talked about that. Property description including parcel code, classification, just talked about that. Assessed valuation, just talked about that. State equalization value of the property, I think we just talked about that. All right, so what they were talking about up here, these are all tax assessment rolls. Tax. Where was this one at? and completion. Okay. So here's where I talked about the name of an owner and the occupant, the property, assessor's valuation, board of review valuation, so forth and so on. That really sounds like what they're talking about right here. Right here. Property owner, agent. Well, I guess you're going to want to ask for both. That'd be the simple thing. Well, show me the tax roll and show me the assessment roll. Again, this is why it's good to have this, because you take this book in and say, well, I want to see the one that it talks about in this paragraph, and then I want you to show me the one that it talks about in this paragraph. And see what they bring you. Right? We're not trying to get it all figured out at one time. Right now, it's a matter of going to getting information, and that's why I do these videos, to hopefully somebody get off their ass and go ask somebody something. Because, I may run into somebody who's just an arrogant troll and not going to do anything. You may run into an angel. And that's what you were meant to do, and that's why God has that person there, because at some point you were going to come ask this question. So please, go find out. There should also be a column for each tax and special assessment to be spread, and the column for the total of all taxes, special assessment spread, blah, 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 blah. This goes on and on and on, right? So I don't want to go through that too much more, because these videos just get too long after a bit. I can't talk that long. But I did want to at least go now and look at this thing about the property, real property descriptions. Okay, sit up, straighten your chairs, and listen up. A legal description is to a parcel of property what a name and address are to a person. And they're hiding our name and addresses from us right now. Everything that you show up on, your name is backwards. Rytlewski, Robert Allen. Or it's your all caps name. Isn't you? Or it's a middle initial name, which is a fictitious name. They don't want your proper person to show up. Mine would be Robert Allen Rytlewski. Proper case. They don't want him to show up in anything. And they don't want to give me an address. They gave my all caps a mailing address, but they didn't give me, my proper person, an address. I'm considered homeless. You're considered homeless. And the reason is we haven't gotten our paper. We're not showing up on the assessment roll as being in the property that the local assessor is assessing. It's a known fact, however, that through errors in copying descriptions, much land is doubly described, and while I should read this whole thing. So, there are approximately 4.5 million property descriptions in Michigan. Theoretically, no two of these descriptions describe the same piece of land. It is a known fact, however, that through errors in copying descriptions, much land is doubly described. Oh, so it would be on the roll twice then. That's what they're saying. While other lands are covered by no description. It will be the function of this chapter to aid assessing officers and others to understand real property descriptions and detect and correct the errors. We would be those others they're talking about. So there are three different methods generally used describing land in Michigan. The first, known as rectangular survey or acreage description, is a system of describing parcels by the section of regular subdivision or a regular subdivision of a section, town, range, survey township. Not the political township, the survey township. Also known as a congressional township. As laid out by the original General Land Office survey, the GLO, the second, meets and bounds, for describing parcels which are not a regular subdivision of a section or are too small to be simply described as a subdivision of a section. That would be like your house lot. The third, platted recorded plat descriptions, is a method of describing lands by lots and blocks after the area has been surveyed, platted, recorded in the Register of Deeds office in the county, and this is interesting, and in the office of the Department of Commerce in Lansing. The platted or recorded descriptions of property, whatever that's including, is in the office of the Department of Commerce. Wonder why that is. In addition, there are referenced land titles take place rectangular survey references. The lands are referenced by their assigned private claim numbers, special treaties, and a few simple rules. When first read, this is the description: north half of northeast quarter of Section 34, Township 3, North Range. Section Township 3 North, Range 4 East of the Michigan Meridian. When first reading, this description may fail to make sense. After a few simple rules are understood, however, it should present no difficulties. The cardinal rule in reading acreage or rectangular survey descriptions is to work backwards, because it's common practice to place the general reference to the location at the end and the specific location at the beginning of the description. To locate a parcel, the procedure is similar to that of locating a residence of an individual from a mailing address. At the bottom of the address is the state, next above the city, next above the street address. Just as the street address cannot be located without knowing first the city and the state, the first name, or the first part of the legal description, is meaningless without the general reference at the end. I told Bobby last night I thought they were talking about the city and the county being part of the general description, but I just think they mean, you start with the Michigan Meridian. Well, that's on a map. You can find that. And we're range 4 east. Well, each range is the width of one township, so it's 4 townships, which are 6 by 6 blocks. So it's 24 miles basically east of the Michigan Meridian. Township 3 north of the Michigan Meridian. Section 34 of the 36 sections. And the north half of the northeast quarter of the 34th section, which is, I believe they start at the top, right, 1, and at the bottom, right, 36. So this is the last row, second from the last. Range, and so if you really want to know, hey, this will tell you all about it. I'm not going to, well, I highlighted it for myself and I was reading. I'm not going to go through this right now, but anyways, that's the main thing, is you got to have the right legal description. And if it's acreage, it has to have acreage. If they're using a rectangular survey, as they call it, well, then it has to have some acreage involved with it. Well, that's what this should have. North half of the northeast quarter, although that does tell you what it is, because of the north half of the northeast quarter. Section 34. So each section is 160 acres. And half of that would be 80 acres. Okay. Give me just a second here. So, in Michigan, this real estate transfer tax, which is a tax that's supposed to be paid to transfer the real estate, I'm going to say it's the $10, but I don't really know what it is. It's its own act, right? It's not part of the. You won't find this information where you look at how deeds are recorded and so forth. This is in a separate section, but it has to do with deeds being recorded. In other places, it may be part of your general property tax law, but at some point, there's a tax that has to be paid for the transfer of property, and I don't believe this tax is being paid. And so, for instance, a written instrument subject to the tax imposed by this act shall state on its face the total value of the real property, and there should be attached to the instrument an affidavit declaring the total value of the real property. The form of the affidavit shall be prescribed by the State Tax Commission. So you got the the document that's going to a written instrument subject to the tax imposed, so it's there to transfer the property, basically, because this is what this is about, transfer title. It's going to have an affidavit attached to it. So there's two documents. Now, the tax imposed by the act shall be evidenced by affixing of a documentary stamp or stamps to every instrument subject to the tax. Well, that would be the thing to transfer the title. Imposed by this act by a person making, executing, issuing, or delivering such document. Documentary stamps shall be purchased only in the county for which the property is located. The stamp shall be affixed in such manner where removal will require continued application of steam or water, and the person using and affixing the stamp shall write or stamp thereon his initials and the date upon which the stamp are affixed and used, so that the stamps may not be used again. Not just his initials, he has to put on the initials and the date. Why, I shouldn't say that. Person using or affixing the stamp shall write or stamp his initials and the date upon which the stamps are affixed, so forth. And I think that these should be on the warranty deed. In Illinois, they are on the warranty deed. In Michigan, I don't know that you see them, but as we're going to see, well, they may be on the back. But that's not the affidavit then. That's the instrument used to do the transfer. But it talked about this affidavit. Preparation of stamps, duty of treasurer, use of tax meter machine, shall make provisions. Okay, so basically that you get them from the treasurer. We don't need to read all this. Most of this I did on my last video, right? I'm just trying to add to that with a few more bits of information. So, recording requirements, detachment of affidavit. No written instrument subject to this act shall be recorded in the office of any register of deeds of the county, of any county of this state, unless documentary stamps as required by the act have been purchased at the time of presentation by the party responsible for the purchase according to subsection 2, which is the grantee, the grantor. It said they had to be purchased. Pay attention to that. It didn't say it had to be attached. They had to be purchased. No written instrument subject to this act shall be recorded in the office of any register of deeds of any county of this state unless documentary stamps as required by this act have been purchased. The stamps shall be affixed to the face of the instrument prior to recording unless the person specifying specifically requests that the instrument be recorded prior to affixing the stamps. What the fuck is that about? Well, that would be so the stamps don't show up. Duh. In the latter case would be where it's been recorded. They've been purchased, it's been recorded, but they haven't been affixed to the front. The stamps may be affixed to the reverse side of the instrument. Oh, okay, well, now we'll put them on the back instead. You won't see them on the front. You go get a copy, they won't be on there. Doesn't mean they're not on the back. They're just not on the front. However, in those cases where it is necessary to record the reverse side, which now it would be because they're not on the front, the stamp shall be affixed after recording by the Register of Deeds. What this is saying is somebody's going to purchase the stamps because it can't be recorded without purchasing them. They're going to have it recorded prior to putting the stamps on, and then they're going to have the stamps affixed to the back. But the backs won't be recorded. And so if they haven't been recorded yet, you would have to go in and say, record the back. Is what I'm thinking. This is for Michigan now. Somebody in Michigan, please go down to the Register of Deeds and tell them to record the back of your frickin' warranty deed and see what happens. But the affidavit we talked about, an affidavit attached to a written instrument under the provision of this act shall not be recorded and shall be detached from the written instrument prior to recording of the instrument. Such affidavit shall be used for county fund auditing purposes only and shall not be disclosed to any other person. Why that's important is other places, in other states, this affidavit would be detached and then it would be sent to the town assessor. And in Michigan it used to be, and then they changed the law and said they weren't going to do that, and now the assessor doesn't know what happened. So in 1994, because this affidavit is no longer going, it's no longer going to the assessor, they came up with a property transfer affidavit. This form must be filed whenever real estate or some types of personal property are transferred, even if you're not recording a deed. It is used by the assessor to ensure property is assessed properly and receives the correct taxable value. It must be filed by the new owner, not the old owner, by the new owner with the assessor for the city or township where the property is located within 45 days of transfer. If it is not filed timely, a penalty of $5 a day, maximum $200 applies. The information in this form is not confidential. They're going to share it. Outstanding. Now, so this is the one I did, and I wish I would have grabbed a different one because I would show you the instructions that are on the second page. I don't have those instructions on here, I don't believe. But it goes on to say that it's for certain kinds of personal property, such as, if you're a renter, basically. So I said, okay, well, this is what I need to fill out. Is I'm renting this property, and this is under P8 Public Act 415 of 1994, which is one of these acts they don't have online. It always makes me wonder, because they have so many of them online. Why isn't that one online? They're trying to hide the information. But the street address of the property, the county, the township, the date of the transfer. There is no purchase price. I didn't purchase it. I'm just using the property. I have the beneficial use, right? That you have to do this even for the beneficial use. The seller or the transferor, because that's what he is. He didn't really sell it to me. He just transferred the beneficial use to me. The buyer, the transferee, the guy who gets the beneficial use, and the mailing address. Well, I put the mailing address is actually in the name of my all caps. It's not in my name. It's an all caps name, so it'll be him. But the buyer is me, so proper case, uppercase, mailing address. And that was really all you had to do, because it says 9 through 13 are optional. And then I certify the information above, true and correct, best of my knowledge, and it said owner signature, so I just crossed out owner and put signature. Your signature has nothing to do with scribbling. You can print it. Hell, to me, that's a scribble anyways, right? Or to most people, my printing is somebody else's scribble. So that's my signature. And if the signer is other than the owner, print name and title. Okay, well, I printed my name again, and I said I'm an inhabitant because I want to be an inhabitant of the township. And they had to attach a description. And so this is the description to this property. And remember I said before on the tax roll it shows up as 0.00. But in the legal description it shows up as 12.37A. And A period is a acceptable by the assessing manual abbreviation for acre. And so there's some kind of transfer affidavit. We're going to look at a couple other states to show you that they're all kind of different, but they all are doing the same. Where there's the way the system works is by omission. They only tell you shit up to the comma. They don't tell you the rest, right? So they omit material facts that you need to do what you need to do. And one of the things is you need to let the local assessor know that you now inhabit the house and make sure it's on his tax roll or on his assessment roll. With you as the proprietor, owner, occupant, whatever the proper term is going to be. So, but still, this act that I just showed you, Real Estate Transfer Act, is mainly to point out that there are these revenue stamps. Now, Arizona, they don't use revenue stamps. They only charge you $2 to transfer the title. They're not doing it with revenue stamps. But they are in Illinois, and they're doing it in Michigan. I don't know where else they're doing it. You just want to find out what it takes to transfer the title. But we have these revenue stamps we're going to use. And they talk about this affidavit. But the affidavit in this case doesn't do anything because it doesn't go anywhere. In Arizona, they have an affidavit, and it says that it goes someplace, and the same with Illinois. So they're all different, but they're all the same. And what they did here, it looks like, is they put the damn stamps on the back of the paper, and they've never been recorded, so the recording isn't quite completed, and you need to go tell and record the backs of the damn paper. I'm thinking. Okay, I got to go get some other paper. Now here's another one, and I wanted to point this out earlier. I didn't. All these are Michigan Department of Treasury at the top, right? And these are all papers that have to do with sending stuff to the local assessor. And this is the principal residence exemption. Read the instruction page before completing the form. Completion of this affidavit constitutes a claim for principal resident exemption, PRE, when filed with the local assessor of the city, township where the property is located. The deadline to file the affidavit for taxes levied after December sometime, blah, 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 blah. But we got to make sure that we're using the right information, right? What is the property tax identification number? Well, don't guess at it. Go look at the assessment roll, the tax roll, have them tell you what it is. Accept their oath, bind them to it, remind them they have a fiduciary duty. What is the property tax identification number? Yeah, have the assessor do this. And so that's my way of looking at this, right? I'm going to have them do it all. And I found this other form I thought was just wonderful. Authorized Representative Declaration. Again, for the Michigan Department of Treasury. This form is authorized to authorize Michigan Department of Treasury to communicate with the named individual or entity acting on your behalf. Use this form to designate representative, receive copies of correspondence regarding a particular tax dispute. All information designated as required must be supplied for this authorization to be effective. So I said the taxpayer is my all cap letter name. I'm not the taxpayer. I'm a sovereign. I collect taxes. The taxes are for me. I'm the king. If I got a taxpayer, it's my all caps. Now, actually, they want you to think your taxpayer is the guy with the middle initial, and I've had this conversation with Treasury before. That they want to know how I was, what my relationship was with the taxpayer. And I said, well, who are you talking about? Who's the taxpayer? Because they wanted me to say it was me. I said, we talking about the guy with the middle initial? They said, yeah. I said, well, that's not me. I don't have a middle initial. I got a middle name, right? That is not me. No. If that's the taxpayer, it's not me. He may be my property, but he's not me. But for sure, this all capital letter name that the taxpayer is, that's actually the name that's on your Social Security stub, is the middle initial name. Right? That this all capital letter name is my property, and so is this Social Security number. And so basically, I made the assessor my agent for anything to do with the Treasury Department because they handle all the Treasury forms. And I just sent this in here the other day. I guess on Monday I got it in the mail. What's today? Wednesday. And I haven't heard from anybody yet, but, you know, they haven't seen this kind of stuff before, so they got to, I'm sure, ponder it a bit. So, but again, here's another form that if you wanted to do this, you got to take it to the local assessor, and you want to make sure that you're using the property tax identification number. I'd have to go read the instructions to see exactly what that is, and they'd have to show it to me and show me where it came from, and have them show you the law where what they're giving you is what the proper number is. But if you put that in, you put your street address, right? And now you're going to have your name and so forth. Well, you're going to give this back to the local assessor, and, you know, it will go onto the record, and you're going to be seen as the owner of the property, claiming an exemption because it's your domicile. Principal residence address is just not one of your residences, it's your principal. Well, that's the same to me as saying it's your domicile. You can have many residences. You could have, cottage on the lake and your condo down in Florida and whatever else you have, but, one of these places is what you want to claim as your domicile so that you can be an inhabitant and have the protection of the city or the township in legal matters. So let me show you what... Okay, so in Illinois, they use this thing called a P-tax, 203, Illinois Real Estate Transfer Declaration. Please read the instructions before completing this form. This form can be completed electronically. You could do that also, right? And I think it was on the instructions. Yeah, the information requested in this form is required by the Real Estate Transfer Tax Law. Well, there you go, another transfer tax law. All parties involved in the transaction must answer each question completely and truthfully. And, right, identify the property, the PIN number, and we'll find that they're doing that wrong here in Illinois. They're using 0000 at the end if they even use it. Or they're not using it at all, and it should be 0040 for a single-family residence. Date of the instrument, type of the instrument. Will the property be the buyer's principal residence? Well, yes. Right? Or you're using it for a rental. Da-da-da-da-da. This form is supposed to have been filled out, and, well, let's go read the law and see what's supposed to happen. Well, there we are, Real Estate Transfer Tax Law. Imposition of tax. A tax is imposed on all privileges of transferring title to real estate located in Illinois. Paper revenue stamps. Oh, they're going to use them too. The tax shall be collected by recorder, register of titles of the county in which the property is situated through the sale of revenue stamps, the design denomination form, which shall be prescribed by the department. And the department is the Department of Revenue. The department shall prescribe the form to which the stamps must be affixed, that a transferee must file for recordation at the time a declaration is presented. If a transferring document is not presented for recordation within 3 business days, that transfer is effected. I'm not really sure what that means. A person using or affixing revenue stamps shall cancel it, and so deface it as to render it unfit for reuse by marking it with his or her initials and the day, month, year when affixing occurs. The marking shall be made by writing or stamping in indelible ink or by perforation with a machine or punch. Okay. Transfer declaration. That's what this is. All right, this thing here is a transfer declaration. At the time a deed, a document transferring a controlling interest in real property or trust document is presented for recordation, or within 3 business days after transfer is effected, whichever is earlier, there shall be also presented to the recorder or register of titles that declaration, signed by at least one of the sellers and also signed by at least one of the buyers in the transaction, or by the attorneys or agents for the sellers or the buyers. The declaration shall state the information, but not limited to all this stuff here. Except it was provided a deed, a document transferring controlling interest, real property, requested in the declaration, shall not be accepted for recordation unless it is accompanied by a declaration containing all the information requested in the declaration. When the declaration is signed by the attorney or agent on behalf of sellers or buyers who have power of direction to deal with the title to the real estate under a land trust agreement, and again, if you don't have the title, then it's in trust. You don't have the title deed. You have the warranty deed, grant deed, but you don't have the title. So it must be in trust, which means, well, now there's a trustee. The trustee being the mere repository, in other words, you put it on deposit of a record legal title, with a duty of conveying the real estate only when and if directed in writing by the beneficiary or beneficiaries having the power of direction. And that could be what this is, right? This is the declaration to transfer the damn title. And the way they did this in Illinois, because I've done quite a bit of study in Illinois, that the Torrens system was used in Illinois. And that's a system of registering land. And the very first step in getting the system to go is that the guy that had the title at the time had to petition the Court of Chancery for them to take his title and give him a certificate in its place. Now, how they pushed that through, 100 years ago, I don't really know, but that's what they did. They took the title. And so the court, that would make the court the trustee. Now, I don't know if they kept it. They may have gone back. I don't know what happened to the title exactly. I still think it's local in the township or the city or whatever your local jurisdiction is. The declaration form shall be prescribed by the department and shall contain sales information questions. Okay, whatever. This is the good stuff. What's the use? If you're in Illinois, pay attention. The recorder or register of titles shall not record the declaration, but shall insert on the declaration and all attachments the document number assigned to the deed or trust document, and shall within 30 days of receipt transmit the declaration to the chief county assessment officer. So when they send it to the assessment officer, it's going to have on it the document number that would take you to the deed or the trust document that you would need to do the next thing you need to do with it. My opinion. The Chief County Assessment Officer shall insert on the declaration, because now it's with the Chief County Assessment Officer, the most recent assessed value for each parcel of the transferred property and other information required by the department, and within 30 days of receipt or within 30 days of adjournment of the Board of Review for the previous assessment year, whichever is later, shall transmit all declarations to the Department of Revenue in this case. They don't have a Treasury Department, they have a Department of Revenue. So who has the declaration when it's all said and done? The Department of Revenue. The Chief County Assessment Officer may also copy and retain any information relating to the property transferred to assist in determining the proper assessed valuation of the property transferred and other properties in his county. What we want to know is, hey, did you ever see my transfer declaration? Because while it says you need to sign it, I believe you can have an agent can sign it in your place, and that's what the closing agent would do. He'll sign it for you. Thank you very much. Okay, deposit of the tax revenue. Okay, real estate and civil township. If the real estate described in the deed is located in a civil township, the recorder or register of titles shall transmit a copy of the declaration to the township multi-township assessor, so they should have a copy. But in all counties, each transfer declaration filed under the law shall include a written statement by both the grantor and the grantor's agent and the grantee and the grantee's agent that the information contained in the declaration is true and correct. So even if you signed it, the agents have to say it's true and correct. That would be the closing agents. Penalties. All persons who willfully falsify. So they weren't quite true and correct. The value to transferred real estate or on the transfer declaration required by section 3125, or who willfully falsify, willfully omit other information, shall be guilty of a Class B misdemeanor. Any person who knowingly submits a false statement concerning the identity of a grantee, well, that would be, you, if you're buying the property, your identity. Any person who knowingly submits a false statement concerning the identity of the grantee under the provisions of this article, that'd be a Class C misdemeanor. A second or subsequent conviction of an offense is a Class A, B, and C. We got them all covered. After that, you go to felony. A prosecution for any act in violation of this act may be commenced at any time within 5 years of the commission of the act. Only the buyer or the buyer's representative shall attest to the accuracy of the financing information. Well, that would be the grantee. Right? But we haven't even seen it yet. So where is this thing and who signed it and where's it at? Well, here you go. Public record. Transfer declarations under this article are public records and shall be made available for inspection upon request during regular business hours. Check for violations. The department, this is the Department of Revenue, shall conduct spot checks or investigations of declarations required to be filed with this article and may forward information of violations to the state attorney of the county where the violations occur for prosecution and collection of taxes. So if you contact the Department of Revenue to find out about your declaration and there's something wrong with it, well then they are going to prosecute because they are interested in the king's revenue. Outstanding. And that's the P-tax form. Okay, I'm going to do this one more time and go get one more and we'll be done. Hang on a second. We might have a little more to do than I thought. So, these manuals are so freaking wonderful, right? This is the introduction to mapping for assessors, right? You just want to search on the word, your state, and assessor and see how many different things come up and take a look at them. But, mapping is almost what the deed is because, X marks the spot. That's your piece of the earth. And that would be on a map. And I'm not going to go through this whole thing, but I need to go to page 89 to show you what I want to show you here. And the reason for that is in here I was looking for legal descriptions, and it ended up being on page 89. All right, how are they doing legal descriptions? Principles for assigning property index number, PIN number. That's what they use in Illinois. They got a PIN number system. Assigning property index numbers and concept and exceptions. Creating real property, location of real property using a PIN. Create a PIN. Understand the use of exceptions, terms and concepts. Let's make it difficult. The PIN is another form of legal description. This is due to the fact that just like written legal description, a PIN identifies one specific parcel. If a parcel splits, the description of the original and new parcel change, therefore the PIN must also be changed. There are principles for assigning PIN numbers. When used consistently throughout the county, finding parcels based on PIN is equivalent to using a written legal description. When assigning PINs, these principles apply. A change in ownership without a change in property boundaries does not necessitate the new parcel number. As long as the boundary for the property is not changed, like a written legal description, the PIN does not change either. Parcel split required the original number to be retired. The original owner, grantor, would be assigned the next available number, and the new owner would be assigned the next number after that assignment. I need one other piece of paper. Hang on. Okay, so here's a brother in Illinois that's in a foreclosure, but this is his warranty deed. And this warranty deed has here permanent real estate identification number, PIN. 2433-103-016-000. Okay, and then if we went to his foreclosure paper, where it talked about it, well, they call it a property index number, and it doesn't have any zeros on it. So right away, it's like, well, this is not the same number. There's only one number to the property. Which one is it? Is it this 2433-103-016? Or is it 24331030160000. Well, I don't know. Let's go read and find out. Hey, we got the book. Let's see what it says. Once a parcel is placed on the assessment roll, it becomes legal description. Consequently, as stated above, when the boundaries of a parcel are changed, the resulting parcel number must have a new number, blah, 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 blah. A PIN, right? Now, this is the assessor's book for Illinois. This is what they're telling the assessors. A PIN is a 14-character series of numbers that describe the geographical location and use of a specific tax parcel. No two parcels share the same PIN. Example: 07322030210040. Okay, well, 2433. So we got a 2-digit, a 2-digit, a 3-digit, a 3-digit, a 4-digit. A 2-digit, a 2-digit, a 3-digit, a 3-digit, and a 4-digit. But this has got 0040 at the end. Use or unit number. This has got 0000 on the end. Well, let's go see what the use or unit number is. I hope I can. I hope I remember how I did this. Yeah, here we go. Okay, this went through each one of them. That's how this was working out. It will tell you everything you want to know about where the number came from. So what number do we have to work with? I should have wrote this down. 07322030210040. That's on page 90. Okay, so what's the first two numbers? In this example, there are 15 county townships, referring back to the example PIN on the previous page. County Township 07 is being highlighted. This is the first and second digits of the PIN. All right, so this is one of those irregular shaped townships that for whatever reason is this shape, or county with the regular shaped townships, but they say it's number 7. That's how they numbered it. It isn't the number that was on the township survey. This is how the county gave numbers to each township. In this case, it's number 7. Right, 07. Okay, the number of the section, so 07. And then it was 32. Okay, there it is. Well, there's 32. Right, we got those two. That's simple enough. And then block number 203. Where's 203 come from? It's going to be up here. The block number refers to the quarter section within the section. The number of the block begins in the northwest quarter of the section and progressively west, north. Anyways, the 1s are here, the 2s are here, the 3s are here, and the 4s are here. So because this is a 203, it put it in the 2, which is between two, it's going to be a number between 200 and 299. In this case, it's 203. It's a block number. The parcel is unique to the property within the block. Typically, the parcel numbers are assigned in the order of creation. So, that's where the 201 came from. 201, 202, 203. Okay. So this is 203. And then you have a unit. Refers to taxable use of the property, the condominium, so forth and so on. With all these different numbers on it. And so basically the one that we're most interested in, at least for me, is this last 4. Because that's residential with a dwelling. Could be residential vacant, could be commercial commercial business, could be rural, could be, but it's not 0000. Residential with a dwelling. The PIN has 14 digits. The first 10 digits refer to geographical location. The last 4 digits refer to the use of the property. And, on our brother here, they put 0000. So the number's wrong. Right? They put the wrong number on his warranty deed. Well, who made the warranty deed? This instrument was prepared by Donald P. Bailey, attorney at law. Wow. Well, I think he's simulating a legal process and using color of law, and he needs to go to prison for it. Well, contempt of court, lose your bar card, back to the fleet. That's what Lord Coke would say. But, they do it all over the place. This is a property card from a township that's supposed to have the PDF, whatever that is, and the PIN number. And again, 0000 at the end. There's no 0040. And if you look at the tax card to that one, right, parcel number 3936303002, they don't have no 0000. So what parcel number is this? It has nothing to do with land parcel. And the way you can tell that in this case is go down here and acres 0. Now this is a smaller lot anyways. It's 2/10 of an acre, but still it's 2/10. That this should say 0.2 acres. No, they put 00000. And so they're using these fictitious parcel numbers and all these things other than what was established by the assessor in the first place, and the left hand doesn't know what the right hand is doing. Let's see if we can help them out. Hang on a second. Okay, just one more state we're going to look at, and then I'm going to wrap it up. This is in Arizona, and it talks about an affidavit of legal value. Each deed evidencing the transfer of a title. That's all we're talking about. We're trying to transfer the title. And any contract relating to the sale of real property. Okay, so you got a deed evidencing the transfer of title, and a contract relating to the sale of real property shall be appended at the time recording an affidavit of the seller and the buyer to the transaction. To me, it sounds like there's 3 pieces of paper. You got a deed, you got the contract. Well, that to me would be like the warranty deed, really more like a contract. I don't know that that's true. I got to be careful what I say, because I get sharpshooters will shoot you down for being wrong, and I very well could be wrong. It just sounds like there's 3 pieces of paper involved here. I'm not going to say what they are. Have them tell you what they are. An affidavit of the seller or buyer to the transaction, or agent of either seller or buyer, and then it has to have this information on it. So this affidavit of the seller and the buyer to the transaction has to have the name and the seller, name and address of the buyer and the seller, name and address of the tax statement may be sent, complete legal description of the property, situs address, date of sale, total consideration. Right, so total consideration. Well, what is that? Well, if you look at the way a warranty deed's written, it'll say for $10 in hand paid and other valuable consideration. That's the total consideration. $10 in hand paid and other valuable consideration. Now, if they want a number for the valuable consideration, well, that's different, but I don't know. Let me see. The name and address of the person contact contain the affidavit. If the beneficiary of foreclosed trustee deed receives payment, no, I don't want that. The county recorder shall refuse to record any deed in any contract relating to the sale of real property if a complete affidavit of legal value is not appended, unless the instrument bears notation indicating exemption pursuant to 1134. The affidavit is complete for purpose of this section if all the information is stated on the affidavit or is indicated on that form as not applicable. Transmitting an affidavit or data to County Assessor, Arizona State Library, Archives, Public Records, Department of Revenue. The county recorder shall place the fee or recording number of the deed and the date of recording on the original affidavit. Scan the affidavit and transmit an electronic copy to the Department of Arizona State Library, Archives, and Public Records, and transmit either the original or electronic copy of the original to the county assessor. The county assessor shall transmit the data contained within the affidavit to the department. And I believe it would be the Department of Revenue, whoever they mean by the department, but it's, Treasury, Department of Revenue, Treasury Department. The county shall transmit the original affidavit when no longer in active use to the Arizona State Library, Archives, and Public Records. Before recording a deed or contract relating to the sale or transfer of real property, the county recorder shall collect a fee of $2 for the deed and contract. In addition, a fee collected pursuant to 11-475. So there's this $2 and then another fee, which is one of these in here. $15 for each deed that transfers, conveys, or affects an interest in real property. So there should be a receipt, and receipts are public records. There should be a receipt that shows that a fee of $15 was paid and a fee of $2 have been paid for a deed to have been properly recorded. And if it was properly recorded, then this affidavit of, what they call this thing? Affidavit of legal value is either with the county, because the county recorder's got it, and now they're going to scan it and transmit an electronic copy to the Department of the Arizona State Library. The county and transmit either the original or an electronic copy of the original to the county assessor. So what's the county assessor have? Now it said for legal value. Now they do have one. That says affidavit of property value, but didn't say legal value. Right? So and the assessor's parcel number, and they got this number on here, and this looks like the form it should be, and so forth, until you go look at a little closer, and you look in their manual. And in their manual, again, this is the Assessment Procedures Manual, and we're just going to audit their procedure to see how they're doing. And it says I can't highlight it. Parcel identification for property taxation purposes is accomplished through the use of a parcel coding system. This system of parcel identification incorporates an easy-to-understand method that utilizes a county identifier, a tax book number, a tax map number, and a parcel identification number. This system meets the standards of uniqueness, permanency, and simplicity and uniformity. In Arizona, a combination alphanumeric coding system is used to generate parcel identifiers. A parcel identifier includes, and again, they're going to use 2 digits to identify the county. So Bob, the guy who sent me this, he's in Maricopa County, should be 07. Then a 3-digit tax book number. And then a 2-digit tax map number. And then a 3-digit parcel number. All right, so 01, 100, 40, 010. Parcel identification examples, right? 01, 100, 40, 010. But that isn't the number, or that's not even close to how they did it on here, where it's book, map, parcel, split. So they wanted the assessor's parcel number. So is this the number they're speaking of? The 01, 140, 011, or whatever your particular number ends up being? Or is it the book, map, parcel, split? It's like they're not asking for the same thing. And so I don't know exactly where we're at with this right now, but we're going to find out, well, where's this at? Right? Again, this is all stuff that's done by the Department of Revenue Assessment Procedures Manual. How do they assess property? Well, let's go read the procedures manual and let's take it to them and say, well, it says in this chapter here, on chapter 1, 6113, the system of parcel identification incorporates an easy-to-understand method which utilizes county identifier, tax code, tax book number, tax map number, parcel identification number. What is mine, please? And see what they give you. That's how we're going to get this done, right? By going and asking a bunch of questions. Because there's, in every case so far, there's been more than just the deed that needed to be recorded. There's other things that have to happen. And that's the stuff after the comma, and that is the stuff they don't tell you. And that's an omission of a material fact. And that could be construed as a false statement. That's what they say. Okay, one last thing maybe. Hang on just a second. Michigan compiled laws, and this is the section of law that has to do with townships, in which it says, and this is why we need to be seen as an inhabitant, not as a transient, not as homeless, right? If you have your mailing address on your driver's license and give it to the cop, well, that's not where you live. And they can't find you where you live anywhere because you never told the assessor of the township where you live. You never put a claim into the assessor. How did it work in the old days? Right? I mean, it seemed to me when people had mining claims, they went to the assessor to stake their claim. And, it was for a mine, yeah, but it was for a piece of the earth. Surveyed piece of the earth from here to here to here to here. And, so the assessor for the jurisdiction you're in doesn't know that you're there. But this is why. So you're not seen as an inhabitant. Inhabitants of an organized township as body corporate. Powers and duties, generally acquisition of property for public purposes, suits, act, or proceedings. Supervisor as agent. The inhabitants of an organized township are a body corporate and have, in addition to other powers that are conferred, all of the following powers and duties. To sue and be sued and appoint necessary agents and attorneys for that purpose. Well, that's why I appointed the assessor. Because I'm going to be an inhabitant, and we'll see, they work for the county, or for the township, so I make them my agent. To make contracts necessary and convenient for the exercise of their corporate powers. In addition to the other powers that I confer, the township board may investigate any matter that is under the jurisdiction of the township and authority vested in the township or an officer under this act. For instance, in my township, there's an ordinance that says any public utility has to have a franchise with the township. Actually, it's out of the Constitution. It says that, which means Consumers Energy needs to have a franchise with the township. Well, they don't. Number one, because they're not actually a public utility. They're not even a company. It's an assumed name of an ill-formed company from Maine. I did many videos on that already, but I'm just saying. So now they can investigate, but first I got to be an inhabitant. The supervisor of the township board, by majority consent of the township board, member serving may serve upon a person a subpoena that has been authorized by a court of proper jurisdiction in the county in which the township is situated, compelling that person to appear before a board or committee of the board and examine under the oath or produce a document or object for inspection or object for inspection or copying. In other words, the township is supposed to come to you. If somebody in the world has got an issue with you, they would send it to the township, and the township would come and tell you, hey, you need to come down here and explain this to us. Right? You wouldn't go to the county and you wouldn't go to all these other courts. No, you go to the township. If a person objects or otherwise fails to comply with a subpoena served upon him or her, the supervisor or supervisory board, by majority consent, may file in that court an action to enforce the notice. The court may issue an order requiring the person to appear, be examined, and produce the documents and so forth. So what? May serve upon a person a subpoena. So the other thing they could do, right, is you could bring a complaint to your supervisor about somebody in the world. They could serve a complaint on him to have him come answer in your jurisdiction for what they did. And if they didn't do it, well, then the township could go to the court and have the court punish them for contempt. That's where the courts are. These black robe priests are not the courts. That's an ecclesiastic court. By resolution of the Township Board, a majority of the members serving may acquire property for public purposes by purchase, gift, condemnation. Oh, like abandoned property, lease, construction, otherwise. May convey or lease that property or part that property not needed for public purposes. Well, again, I just think that they have control of all the property because we've never gone to the local assessor, and so we've never shown up, and therefore the property is considered abandoned, and technically the township is the owner of the property again, but they could convey it to you. You go to the assessor and put in your claim. I'm going to claim that piece of property. May happen to have a house on it, but you're going to claim it anyways. Now, you don't want to do that to a house that somebody's in, but hey, if it works, that's how you get your house. A suit or act proceeding by or against township in a corporate capacity shall be in the name of the township. The supervisor of each township shall be the agent for his or her township for the transaction of legal business. Well, there you are. That's why I appointed the appraiser, because as we'll see, the supervisor is supposed to be the appraiser. In just a second. Power to grant vote sums of money. This is the other thing. Inhabitants of a township shall have the power by vote of registered electors of the township to grant and vote sums of money not exceeding amounts by law, blah, 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 defraying the proper charges and expenses arising in the township. The township board or a township officer shall not create a debt or liability against the township or issue a warrant, certificate, or order for the payment of money unless the creation of the debt or liability or payment of the money has been authorized by the vote of the registered electors of the township or by law. So they're not paying the bills, and they put the whole township into receivership because it doesn't pay its bills because the inhabitants haven't told the township to pay its bills. Supervisor is chief assessor. Supervisor of each township is the chief assessor of the township. The township board may provide for the appointment of additional assessors. If the supervisor is not certified at the proper level, the township board shall provide for an appointment of a properly certified assessor. The assessor so appointed shall receive compensation allowed by the township board. If assessors are appointed pursuant to the section, the supervisor shall be the chief assessing officer, and the assessors shall be subordinate to the supervisor. Upon completion of the assessment of making the roll shall be deposited with the supervisor. Supervisor shall be secretary of the board of review. Blah, 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 blah. The township supervisor may appoint a deputy township supervisor who shall serve at the pleasure of the supervisor. The deputy shall take an oath of office and file the oath with the township clerk. In the case of absence, sickness, death, or disability of the supervisor, the deputy shall possess the powers and perform the duties of the supervisor, except the duty shall not have a vote in the township board. The deputy shall be paid a salary or otherwise as township board determines appropriate. I think they made the assessor this deputy township supervisor because the guy that is the township supervisor wasn't properly elected. He didn't file a proper oath of office. None of the people that have been elected have filed a proper oath of office. They're not actually following the election law, so that they're not the people we're talking about. But the assessor is working for the state, not for the local government that the township represents. The assessor, all the forms with the assessor is working for come from the state, from the Department of Treasury. So I think that makes them the the local state officer within your jurisdiction. They represent the state, and you have business with the state, and so you need to go to the supervisor or to the assessor, and not to these yahoos that weren't properly elected. They didn't put in the proper paperwork to run for office. They don't have a certificate of election. All the shit I've talked about before. I don't know if any of this is true. It's just my thoughts, and so I've done the things I've done, as I've shown in this video, and we'll see what they do with them. But if you own property, you need to go down to the local assessor and find out what's going on and see how you show up in the list. And I'm sure I'll do a couple more videos as I refine this on my own head. But this is just too important for me to keep to myself, because it shows there's more involved than just the warranty deed. And if you're in a foreclosure and they're using some number other than the one real estate number that identifies the acreage, right, the land that you live on, then they're not foreclosing on your property. And it would be a simulated legal process, and there should be something we could do about it. Okay, I'm done yakking. You all have a great day. We'll talk again soon. See ya.